Good morning, council. How's everybody?
Good morning.
Hey, Jessica.
I think I can't.
Acacia, you're on.
I'm sorry, my volume was off. Good morning.
What case you here on?
I'm here on the Kang matter.
That is case number 5. Are you moving, respondent, or just an observer?
Respondent.
Respondent. Gotcha. Case number 5. Neil, what case you're on? Neil, can you hear me? Neil? Neil, can you hear me? Put your volume up. Neil?
Morning, everybody.
Pointing at you, Neil. Can you hear me? All right, we're going to say no on that one. We'll get together later. Franco, what case you here on?
Here for the Palumbo matter.
Palumbo. That is case number 4. Are you the movement or the respondent?
The movant.
The movement on 4. Is Neil with you?
Yes.
Aha. See the respondent?
Responded.
See the respondent?
Here,
We're having difficulties here. Both of you, Franco and Neil. Franco,
can you hear me? Can you hear me?
Neil, I got you. Can you hear me, Neil? Okay, you're
I
on
can
case
now.
number 4, the Palumbo matter, correct?
Yes,
Okay, you're the respondent?
yes.
Okay. I'm gonna put both counsel in case number in breakout 4. Maybe we'll get better reception. Franco, you're freezing up on me.
Oh, that's bizarre. I mean, I have a secure connection on my end. How's that?
So what are you trying to say? It's our end? Is that what you're saying? Our end?
I don't know.
We have the most sophisticated equipment that you could buy here at the FJD budget here. Come on.
I'm sure the issue's on my end. Let me try.
City Hall's well-known internet, right, Pete?
Oh, you know.
Possibly be us.
It's top of the line stuff. Gotta go feed the squirrels. Wait a second.
Pete, it might be that Mario Lemieux sign hanging behind him.
Yeah, it could be. It may be. That's right.
Yeah.
All right, I'm gonna put you in breakout room number 4. Neil, I'm gonna put you in breakout room number 4. Click on it. Go into room 4 and see if we can work a few issues out. Okay?
Yeah,
You got it. All right. Pat, what case you here on?
Darsick, moving.
That's case number 6, and you are the movement. All right. Ellie, what case you here on?
O'Donnell, moving.
O'Donnell, and you are the movement.
Yes, sir.
That is case number 3.
Morning, Aaliyah.
Morning, Pat.
Josh, what case you here on?
Hey, good morning, Pete. The SEPTA, Devlin v. SEPTA matter?
That is case number 2. Are you the movement or the respondent?
Moving.
Moving on 2. Mike, what case you here on?
Good morning. We are the respondent on case number 2, the Devlin versus SEPTA matter.
Okay. Put counsel in breakout room number 2. Nobody has ever come out of breakout 2 without an agreement, so pressure. No pressure. Just send you an invite, click on that, go into breakout 2. Aaron, what case you here on?
I am here on Palumbo versus JP Morgan.
You're observant or moving or a respondent?
I am co-counsel of the movement.
Gotcha. I'm gonna stick you in breakout room number 4. there. David, you were on the Kang matter, correct?
That's correct.
And you want to move it?
That's correct. And this is the same type of issue we were here last week for Judge Carpenter. You know, Her Honor's already stated how she's going to rule. So I don't know if we really even need argument on this, or if we can just get forward for 30 seconds and get this one off the list.
I'll put you in the breakout room and let's see what you got, okay?
Maybe I could just go in the breakout room with them, Pete, and if it's the same, then we'll just do something with the, okay?
Yes, Your Honor, I'll put you in there also. Let's send you invite, Your Honor. David. 5.
All right.
5. Everybody should get an invite. Nick, are you on the Kang matter also? Nick? Nicholas? I know you're there, so. I'll put you in 5 anyway. Roland, what case you here on?
I'm here on the Aramark one.
That's case
Long time
number
no
6.
see.
Case
Yes.
number 6. I'm gonna put you and Patrick in breakout room number 6.
Got it.
Got it, let's work it out. Right.
Unmute.
Abe, how are you?
Good. How are you, Pete?
Doing well, thank you. What case you here on, Gabe?
O'Donnell.
Alrighty, so you are the respondent.
Correct.
That is case number 3. I am going to send you an invite along with Ellie. Sign 2, 3. See if
Thanks,
you can
Pete.
work it out. Thank you. 3. There we go. Everybody get them? There we go. ND, can you put your video up, please?
Again, I'm trying to get this to work. I'm on my phone.
If you toggle around all the,
You should be able to.
yeah, there's a, let's see.
Are you here for Discovery Court?
Yeah, I'm supposed to be in Discovery Court. Yes.
All right, what case?
Griffith versus Midas. I'm sorry.
Griffith versus Midas. Is that for Judge Carpenter's Discovery Court or Judge Padilla?
I'm not sure. I actually just hit the link. And that's where I'm at.
And you said on the Griffith matter.
Griffith, yeah. Griffith, it was a motion for sanctions.
I don't have that on my list.
Did something get added, Pete?
I don't think so, Your Honor.
Ellen's not here yet to know whether we
I'm
had,
here, but it didn't come through me.
You have a case number?
Yeah, hold on just a second.
Go ahead, take your time. We're asking you to do a lot of things all at once.
so we can usually help him out. At the bottom of the screen of his phone should be the icons for our video.
My phone right now, that's where it's at.
Yeah. Okay. I found the case number is 210602-204, and I have a control number as well.
All right, 1 second. Let me.
Probably not mine.
Yep. Tom, I'm going to put you at breakout room number 6, Tom, okay?
Thanks, Pete. Okay.
Got it. Good to see you, buddy. There you go.
Actually, this looks like it says it's for Judge Cohen.
Judge Cohen, okay. It's a rule hearing in front of Judge Cohen or a pretrial, whatever it may be. So what you need to do is log out of what you're in, go back out to the court's website.
Okay.
And go, scroll down, you'll pass a few court programs, and you'll get into the individual judges. Once you
Okay.
get to the individual judges, scroll down to Judge Cohen, Dennis Cohen,
Okay.
and click onto his personal ID link.
Yeah, make sure you
Okay.
don't put a link into his Discovery link. Sometimes that's
Right
what
back
happens.
here. Yeah.
Okay.
Okay.
All right. You got
Okay.
it. Thank
Good
you.
luck.
Thank you so much.
Yeah,
Bye-bye.
bye-bye. All right. It's 9:01. Do you think everybody's checked in?
Yep.
It seems like we have more matters than we have lawyers. Did some things enter by agreement?
No. 2 were.
So 5,
withdrawn.
sorry, Pete. 5, they said that they would send you the order that I had entered in other matters, and they're just gonna send it over to you. But essentially, it's gonna get denied without prejudice.
Gotcha. All right, so that's
Okay.
number 5. So 5's off our list. Case number 1 got a new date because they're gonna work that out. So we gave them 2 weeks to work it out. It's a
Okay.
case.
Awesome.
That
I'm
was
sorry, Pete, I
scheduled
missed the
for
number.
11.
Which one was that they got 2 weeks to work it out?
Yeah, number 1. It's 11/8 is the due date.
Okay.
Number 7 was withdrawn, and number 8, they were almost ready to either work it out or withdraw it, so they were not going to show up either.
Okay.
So let's see. Franco, do we work anything out on case number 4?
No, we haven't. And in fact, I was booted out of the breakout room. I'm trying to get back in.
Okay, let me see if I can get you. Yeah. Sign it.
Sorry for the technical issue.
So now I'm really blaming you.
I will accept responsibility for. I'm in the office today. I don't understand why there's.
It's all good.
And with
It's
this,
all good.
Yeah.
All right, so let me go, Your Honor, I'm gonna go into breakout room number 2. If they're not gonna work it out, I'll bring them in and we'll start that
That's
up.
fine. Take your time, Pete. I'm drinking my coffee. I'm not in a rush.
Hey, Pete, before you go, can I just ask, Her Honor canceled Discovery for 11/8. So is that actually a list or just a check-in for number 1?
So that, okay, so then we'll move it to the 15th.
Either way, if you want to have a list for check-in, that's fine.
Nope. Now we'll move it to the 15th. They didn't get a notice yet, so it's all good. I was just,
Okay.
they shot me an email and told me what they were doing. So I told them we'll get a new notice, but
Is the 8th, Ellen, what is that? That's right before Veterans Day, right?
It's election day.
Election
My
day.
birthday.
election day.
And Ellen's, yes, it's special day. And isn't election day that Friday or this? Yeah, 11th.
No, Veterans Day is the 11th. Election Day is.
Election day is the 8th.
Correct.
Veterans Day is the 11th. Okay.
Correct.
This-
11/11.
So Pete, when is it that we're doing the 2022 and 2019 and back combined Discovery? When do we know when the first one of those is going to be?
November 1st.
Oh,
No, November 15th.
15th. Okay.
15th.
So that's going to be a big list. When you get that together, maybe 'cause we'll have to fit. And what are you going to call it? Just as one list or 2 lists? Do you
Well,
think?
yeah, it'll appear on your list. Your 19 cases will be the first. If there's 5 cases in 19, they'll just appear first because
Okay.
it goes in numerical order on our list. So all the 19 ones will go 1 to whatever, and then 2022 will pop in after that.
Okay. How big are oh, sorry, we have people coming in.
Josh, we work that out, Mike?
We pretty much have it worked out, but the issue on ours is a motion to compel a deposition of a minor. And Mike has filed a motion to substitute a different guardian for that minor in this case, and also a motion to stay it until there's a guardianship.
All right, so let's put this on the record, okay?
Okay.
One second. Tina, are you ready?
Ready.
All right. Here we go. In the name of the Commonwealth of Pennsylvania, this Court of Common Pleas Civil Trial Division is now in session. The Honorable Linda Carpenter presiding. Good morning again, Your Honor. Your Honor,
Good morning. What
first
number
case
is on our
on your
list?
discovery list is going to be case number 2. It's the Devlin versus SEPTA matter. I'm going to ask the movant to identify themselves for the record and who you represent.
Good morning, Your Honor. Joshua Groff here on behalf of SEPTA.
Respondent.
Good morning, Your Honor. Michael LaRusso with Dugan, Brinkman, McGinnis, and Pace on behalf of the estate of Devlin, the plaintiff in this case.
All right, so I see that there's a request for the deposition of a minor. Is there agreement that the deposition can go forward, or is it there are some things that need to be worked out before you can have the deposition?
Your Honor, I believe there are a couple of things that need to be worked out. The deposition is for a boy who I believe is 11 or 12 at this point. He had witnessed his stepbrother's death on a SEPTA train a couple years ago. He has his own pending suit for emotional distress. The issue, Your Honor, is that, and I can let Mr. LaRusso get into some more of this, but we filed a motion to compel the deposition of this 11-year-old. Currently, there's a custody dispute between the 11-year-old's biological mother and a guardian who was appointed years ago about the proper guardianship of this young boy. Apparently, there's pending in the family court a guardianship custody hearing for January of 2023. So Mr. LaRusso has filed a motion to stay the matter until that guardianship issue is resolved, which SEPTA does not oppose. The other issue is currently the person that I think Mr. LaRusso thought had guardianship does not have guardianship of the minor. So right now, as the case stands, this case has been kind of stalled for a few months while this issue's been worked out because there's no proper representative for him in the case. But we are down to a month and a half or so of discovery left. So what Mr. LaRusso and I discussed was, Your Honor, as the team leader, possibly addressing a few of the issues in the case. SEPTA consents to a stay until the guardianship issue is resolved. We would request a status conference in February of 2023. And we also do consent to the substitution of someone named Wykina Dantzler, who's the proposed guardian in the proposed amended complaint, because we understand she is the proper guardian for Kamani Devlin, the minor.
So let me ask you something. Is there any other discovery that has to happen other than the deposition?
The deposition of the minor and this person, Wykina Dantzler, who's had custody of Kamani for most of his life. Those two depositions, I'd have to think what else needs to be done. Mr. LaRusso may want to do some, but there is more discovery to be done.
There's more discovery to be done.
There is more discovery to be done, Your Honor.
I'm just hesitant to put an actual stay on anything, because sometimes that's just going to end up being where you can't move forward and you don't get a trial date in it. Isn't there some way that we can either extend the discovery deadline and tie it to somehow to when the appointment of the guardian is done, so that it's not really a stay, it's just an extension of the deadline, so that you don't get lost in the shuffle by, because our team leader system is about to switch again, whereas I take over the 2022 and backward program, and it might be that you get stuck in the stay, and sometimes that can happen. So we could certainly say something. There's no disagreement that the minor's deposition will eventually be taken. So why don't we just say an order that's in front of me, I'll just say the motion is granted. I don't know if you need it as an order because it's a minor, or if it can just be granted by agreement. It is ordered that KD shall appear for deposition of this matter within 30 days of the disposition of the appointment of guardian issues, something like that. Make it nice and vague. So as when it gets resolved, you got 30 days to schedule a date for the.
Your Honor, I think that there may be potentially some complications there, and this is a very interesting situation, I think. But the reality is, right now, so Kimberly Dantzler is the child's biological mother. Her cousin has legal custody. Her cousin, when we found out that the cousin had legal custody in the summer, originally, we had discussed with SEPTA and with her cousin that we would need to amend the complaint. We would need to bring to the court's attention, everybody's attention, the fact that she is actually the decision maker. She was on board with that, Your Honor. She came to my office, she signed a verification, we were good. And then she went radio silent for months. As of right now, there is still an ongoing, what I would call a domestic dispute between Kim and Wykina and Kamani. So the fact that the fact that Wykina technically has legal custody of the child due to the court's order, believe it or not, Your Honor, she doesn't have actual custody of the kid right now. She's not making any decisions on behalf of the kid.
Right, but here's my concern from the court's end. I don't want to stay a case, and in 6 years from now, it's still in our inventory. Sounds kind of harsh, but that's my job as the team leader, is to keep these cases moving. And so I'm certainly willing to work with you guys, but I just don't want, it's a 2019 case. We definitely have cases in our inventory that are like from 2011. And I just don't want that to happen on my watch. Okay. So I'm willing to work with you guys to make it so that we can have it be that you need the time, but I'm not really willing to grant it some kind of indefinite stay, because it just could be, this guardianship issue could be a part of this child's life, unfortunately, until the child is 18 years old.
Could Your Honor,
Because of, unfortunately, it sounds like a situation that there's something else going on as to why a guardian can't, and I'm willing to work with you. I can put a 90-day stay on it or something, but it would be better to just extend your deadlines and then just keep asking for extraordinary relief.
would Your Honor, how far out would Your Honor be suggesting?
I can extend them 180 days from today if you want me to do that. Give you 6 months to figure out what to do. Then it'll be another team leader, and that team leader may have a different way of addressing it, and you can make more specific motions then when you know a little bit more. It may have to go to orphans court. I hate to tell you. I think you might be in the wrong venue, and I'm just letting you know you might need to walk over to orphans court, because it could be that there's an issue. I don't know. It may be beyond what we can do here. I don't know. That's something you guys are going to have to look at, because it seems like, is family court involved in the case?
They're not involved in this underlying litigation with SEPTA, Your Honor, but as of.
Why can't the court just appoint a guardian? Why can't I don't know if that's me or orphans court that does it, but why not just appoint a guardian? Forget about it. Say this child deserves to have this child's underlying case resolved so that this child can, this sounds like the kind of case that's going to settle with a monetary check. This child could use it, could be put in trust for them. And, so why not just appoint a guardian? Have the petition the court to appoint a guardian.
Yeah, Your Honor, and that's something that we had considered. I think the interesting thing that we realized, relatively recently, was that as it stands, what Josh said in their motion about Kim Dantzler not having decision-making authority, et cetera, we don't disagree with that. So we're in a tough position where we don't think we can even file anything, frankly, on behalf of this minors claim. Until
then why don't I do it?
Well, that's until the complaint is amended.
That's why maybe it's the defense that has to do it. I think when you look in the rules, I'm pretty sure it's anybody can actually, it doesn't have to be the plaintiff's counsel. SEPTA could actually be the one to say, you know what, we got to get this going. I'm going to file the request for guardianship. I forget where the rules are, but you asked for it.
We did file something along those lines, Your Honor, just to have the court, to bring it to the court's attention to address the guardianship issue. And
is it in my queue? Is it with me?
It is in your queue. It's not asking for that specific relief, Your Honor. It's just to determine.
Do you have the control number on it? And what I'll do is I'll put it on my separate list. Ellen, you and I can do that. Maybe didn't we create an open day? We could,
but it hasn't been assigned to you yet.
We can put it for December. What is it? 14th.
Sure.
Put that put everything on my list for December 14th. Okay. And if at that time you have to ask for an appointment of guardian, somebody have the rules in front of me so I know whether it's I can do that or whether it has to go to orphans court.
Counsel, is it the motion to amend or is it filed under miscellaneous motion?
It's a miscellaneous motion, Pete.
Okay. Control number for the miscellaneous motion is 22101612.
Pete, that same day was the motion to amend, which addresses the same issue. So
that's fine. We'll put both of them. Ellen, put both control numbers, and we'll hear it on December 14th at 11 o'clock.
Okay. So, that along with this the instant discovery motion as well. Okay.
Yep. We'll put it all there, and we'll figure the case out then.
Your Honor, in the meantime, just to keep this all together, is there a way Your Honor can extend that is beyond the discovery deadlines and expert report deadlines?
The deadlines, how long do you want them extended at this point? The 180 days?
Yeah, if you could do that, Honor, I think that would be
so
totally appropriate.
Is that possible for us to just do an order right?
Yes.
Okay, the deadlines will be extended 180 days from today.
And that's all deadlines, Your Honor?
All deadlines.
Can I ask one more thing, Your Honor? Is it with SEPTA's consent to the, our motion to amend the complaint, can Your Honor enter an order today granting us leave to amend the complaint? And then within a few days, we
No,
can file?
because you can't amend it until you know who the guardian is.
Well, so, and that's kind of, we also can't do anything in the litigation until we know who the guard. So I think here's the issue as I see it, Your Honors, right now, the legal guardian is Joaquina. Like, I don't think that's disputed. Whether or
No,
not she can make.
no, I'm not, I cannot grant something like that until we know that the child's best interests are being taken. That's my job as a judge. I have to know that the child is, and it may be that I just take over and appoint a guardian and that's the way it goes. But no, I can't, because I can't just allow you to file a motion to amend when it's a minor, and I don't know if the guardian is the appropriate guardian, but she is the appropriate guardian, Mr. LaRusso, so that you are in front of the court, the attorney that the court looks to for all pleadings, and that will be your job until this is sorted out. And that's on the record, okay? So right now, she's the presumptive guardian and you are the attorney for that guardian. Okay, but I can't authorize a motion to amend that I haven't even read. I haven't read it. Can't do it. Sorry.
Well,
but if it comes through my queue and I see it before the 14th, I will roll on it.
It was filed the same day. So I think the issue that I'm having, Your Honor, and maybe need some guidance on, frankly, is I'm not sure what I can do in this case as it currently stands, when I think Josh and I would agree that as the complaint is filed right now, it's improper, because right now the complaint lists Kim Dantzler as the legal guardian.
You guys can do any discovery you want. You don't need, you guys, you do pre-complaint discovery. As long as you guys are in agreement, you can do anything you want. And the court has specifically recognized you as the proper attorney in the case. So you guys can continue to do everything. You don't need, and the, you know, the discovery deadline is there so that you can file motions in discovery court. It doesn't prevent you from doing mutually agreeable anything in the case.
Understood. So at least with respect to the subject deposition, Your Honor, that or the motion to compel, as my understanding, will be granted pending the determination.
No, it's just going to be sitting there until the 14th, but nobody's moving on it, right?
So well, and that's my concern. I literally cannot prevent the kid for a deposition.
SEPTA's telling us, no, we're not moving on anything. The deadline's got extended. We all know that you guys continue to work through a solution to the case, but that nothing formal is going to actually happen until the 14th, because there's no way to do it. All right. And then
I'm sorry, it's December 14th?
Yes.
Okay.
Yes.
Okay.
That'll give you enough time to maybe figure out this guardianship issue behind the scenes and have a position for the court at that time.
Okay. I think that makes sense. Thank you, Your Honor.
Thank you very much, Your Honor.
Thank you, counsel.
Yeah.
All right. Take care, everyone.
Yep. Next case, Your Honor, is case number 4. I'm going to ask the movement to identify themselves for the record and who they represent. Counsel, there you are.
Good morning, Your Honor. Franco Corrado from Morgan, Lewis & Bockius here on behalf of JP Morgan Chase.
Good morning, Your Honor. Aaron Bender from Reed Smith, co-counsel for JP Morgan Chase.
Okay.
Good morning, Your Honor. Neil Botel for Gregory and Lisa Palumbo.
Counsel, you're going to need to speak up or put your mic a little closer. It's tough to hear you.
So I am hearing that the defense is asking for a motion to quash the Palumbo's notices of deposition.
That's correct, Your Honor. The Palumbos have served 8 notices of deposition. We are asking, Your Honor, quash those notices.
What's wrong with the notices?
So there's a couple of issues at play here, Your Honor, and if you'll just allow me to provide just a couple of sentences of background on the case. I can then walk through the three principled grounds for granting our motion.
Sure, but just before you do that, Pete, is this our last motion or do we have something else?
We have two more, Your Honor.
Okay. Well, you know what? If this is, and I want to give you plenty of time, but this sounds like this might be more involved. So before you get there, plaintiff, why do you need these 8 depositions?
We need to verify with people who actually took part in the violations of the orders issued by the Federal District Court of Washington, D.C. and the Office of the Control of the Currency. We need to verify with these people how they performed in their jobs at the time that these orders had been issued.
Okay, and so what is the basic claim that the Palombos are making against JP Morgan? What is the issue in the case?
The issue is whether JP Morgan violated Pennsylvania Rule of Procedure 1024 regarding verification of pleadings. In this particular case, the person who verified indicated that he had personal knowledge of the facts surrounding this case, and he signed as a vice president. And this was a system-wide within JP Morgan's foreclosure litigation. This was a common practice.
Okay. And so what is it that you are seeking in the case? What's the ultimate relief that's being sought?
We want to have the Palombos house returned to them. We want damages in the form of mental.
Okay.
Loss.
And so what I mean, and the reason that you want these depositions is that you want to be able to discover their knowledge before they signed off on the materials, which would lead to whether the foreclosure was proper or not.
Yes, that's correct.
So why wouldn't I allow those depositions just for the limited purpose? Sounds like they'll be pretty short, you know? They might be an hour or two apiece. Maybe they could be done virtually so as to make them, you know, very quick, all done on the same day. And I could, you know, indicate that, Mr. Patel, it sounds like what you want is very discreet and that the deposition shouldn't be that long. So why would I quash them in their entirety?
Well, Your Honor, a couple of things at play here, and this is where it's necessary to delve into some background, and then I'll dismantle Mr. Beltel's thesis. Just if you would bear with me for a moment.
Sure.
This action, in and of itself, is a collateral attack on a judgment in foreclosure entered in the Delaware County Court of Common Pleas in 2015. That foreclosure was upheld on appeal both by the Superior Court and the Supreme Court. The plaintiffs here were the defendants in that foreclosure action. They did not have a single substantive defense to that foreclosure, and judgment was properly entered in Chase's favor. So what have these plaintiffs done now, Your Honor? They've sued Chase Bank, not in Delaware County where their foreclosure was litigated, but in Philadelphia County, alleging that the verification attached to the foreclosure complaint in 2012 did not comply with Pennsylvania law because, in their view, the individual who signed it was underqualified to sign a verification. So what we have here is an issue of what Pennsylvania law requires for a verification. And their theory is basically that if the Delaware County judge had known that the individual who signed the foreclosure verification was, quote, underqualified, that the judge would not have entered judgment in foreclosure in Chase's favor. Notwithstanding the fact that the plaintiffs have never disputed the factual accuracy of the allegations in the foreclosure complaint, have never disputed that they didn't pay their mortgage, have never disputed that they didn't engage in any sort of other loss mitigation, and any defense that they did assert to the foreclosure that was substantive has already been determined in Delaware County and upheld on appeal. The depositions they've noticed are improper, and there's three main buckets. Your Honor, the first deposition they're seeking is the deposition of Chase Banks, one of the world's largest banks, general counsel and executive vice president Stacy Friedman. That deposition should be quashed under the Apex Doctrine. Given the role and prominence of a general counsel of one of the world's largest banks, any attempt to depose her should be viewed with skepticism and require serious scrutiny. What's worse here, Your Honor, is that Ms. Friedman had no involvement whatsoever in the Palumbo's foreclosure.
All right, so as far as the general counsel goes, she didn't sign the verification and she didn't have direct involvement. What about?
She wasn't even at the company at the time the verification was signed.
So what about the? I will quash that subpoena.
Okay. So there's two.
Doing that,
But
sorry,
I'm
can
not.
I
I'm
interrupt?
I
I mean, before you quash the deposition, I think we have to have an opportunity to answer the factual issues.
It's
that
in your
exist.
written motions. So
I'm
I'm just saying the general counsel, but as far as the people who actually signed the verifications.
Your Honor, they're not seeking those depositions. That's
Borough
you know,
approved.
so
So let me ask Mr. Botel again. Who is it that actually, as far as whether somebody was there, I'm hearing that the president of the bank or the general counsel of the bank or top leadership on a national level with regards to verifications, if I were to allow that, they have to have been present at the time of the events. And I'm hearing that they weren't, that wasn't their job then. So who was, as far as these verifications were signed in 2012, which of the people are you looking to depose, Mr. Botel, that were either there or actually signed the verification or had some involvement on how verifications get signed?
None of the persons that we have asked to be deposed were present at the time of the signing of the verification. They signed verifications in similar cases at the same time that the verifier posing as a vice president of JP Morgan signed the verification and the Palumbo matter. And so they have knowledge of what they were instructed to do by JP Morgan in order to advance those cases at the time that the Palumbo's verification, Palumbo's
Well, who are they by name? Because what I am telling you is, if there were the people who are noticed were present at JP Morgan and had job responsibilities and or signed the verification, then I'm not sure why I would quash those subpoenas. But what I'm hearing is the people that have been under subpoena don't fit that category.
There are 4 people who are no longer working with JP
Counsel, you're
Morgan.
going to need to speak up.
I'm sorry. There are 4 people who, four people whom I've suggested are working for no longer working for JP Morgan, and we've already conceded that we're not interested in taking their depositions. We're only interested in the employees who were employed at or near the time of the signing of Palumbo verification and are still working for JP Morgan.
Who are they? That's under dispute right now. Who are they?
Let's see. I think one of them is, I believe, named Ida. I don't know her last name.
Okay.
There's Nijak Pajic, David Senesak.
Excuse me, names please, and whoever's making the noise. Can you mute?
So what we're
I'm
gonna do,
sorry.
Tina, I'm gonna ask that the paper that has these names on it be given to the court reporter so she actually can see their names, or if we share screens so that we can have them. But for now, I will just say Ida, Nishek, David, and who else?
I don't see I know there are 4 who currently work for them, but and I'm consulting a September 7th, 2022 letter from from the defendant to me.
Okay.
So
those 4 people are the ones that are subject to this motion to quash?
Yeah. Yes, yes.
Okay.
Also, I just think I need to mention, to clarify the record, that the issues that have been raised by counsel have already been treated at least twice in this litigation prior to today by preliminary objections and a motion to for judgment on the pleadings. And both of those were denied by the court. So, I mean, going over this again,
I understand. I know that, but here's the thing that all lawyers need to understand. Simply because preliminary objections get denied or motion for judgment on the pleadings get denied does not mean that that's coordinate jurisdiction or law of the case or any of those things. The Superior Court has said it over and over and over again. Different stages of the pleadings, different motions being brought for different reasons later on in the proceedings, the judge can still look at them unless somehow there is a direct order which would preclude or create judicial estoppel. But right now, I'm not saying that these will not get ordered, but as far as a discovery matter, I'm not going to have people sit for a deposition on the subject matter of a verification when they weren't at the company at the time or and didn't have any responsibility for it. So I'm hearing that there are 3, possibly 4 people that fit within the category. They were there at the time and that they may have had some knowledge or responsibility for verifying the type of pleadings we're talking about. So what I'm saying is that on that basis, that I would, think that it could lead to discoverable information. But I'm hearing from the defense that that's not accurate. That is right.
Your Honor, if I may, the plaintiffs are trying to treat this matter as a class action. They're not seeking discovery about the verification that was filed in 2012 in the Palumbo's matter. They're not even seeking to depose anyone who had anything to do with the Palumbo's foreclosure. The current employees who they've identified and noticed for deposition had nothing whatsoever to do with the Palumbo's foreclosure. They didn't work the file. They didn't sign any documents in the foreclosure. What the plaintiffs are after here is testimony about general practices and procedures dating back to 2012. So that they can make whatever case they claim they think they can make to demonstrate that the foreclosure verification that's already been, their substantive arguments about it, frankly, have already been rejected by the Delaware County Court.
Here's what I'm saying, and I do think that I'm hearing plaintiffs say that circumstantially what he wants to do is show that the verifications were not proper. And if the verifications of the exact same kind aren't proper in other cases, that's evidence that they weren't proper in his case. And had that information been provided over at the time that the foreclosure action took place, then everything that the Delaware court and the Supreme Court did would be out the window, because there's other case law out there, I believe, that the paperwork has to be a certain way to support the foreclosure action. So it's a little bit circular, but that's what I'm understanding that this case is about.
Well, Your Honor, Chase has never shied away from its discovery obligations in this case.
Right.
To the extent that the Palombos are looking for practices and procedures, which is what they're looking for, the questioning is not directed to employees who handled foreclosure matters in states other than Pennsylvania that had nothing to do with the Palombos. It's a corporate designee, and they can issue, and we've said this in 2021, and we said this to them in just September of this year before the discovery deadline expired, which it's now expired, that if they notice an appropriate deposition, we'd provide them a corporate representative to testify to the practices and procedures that they're interested in discovering. And they've not taken us up on that offer.
What's wrong with that? If I say, you know, the subpoenas for these particular individuals is quashed. However, JP Morgan shall produce a corporate designee most knowledgeable with regards to, and you tell me what that is.
Policies and procedures of JP Morgan at the time the foreclosure was filed against the Palombos, and whether the verification that was signed at that time was proper, or if the policies of the corporation that motivated violation of the rule require the court to find in plaintiff's favor. This has nothing. The case here deals with after discovered violations of law.
Understand that. I get it. And so that's why I'm saying that what I'm hearing is that I do think you're entitled to the information you're seeking, but you're subpoenaing the wrong people. And I do think that a court, maybe they are the right people, but I think that I'm going to say that the motion is quashed by way of further order. JP defendants shall produce a corporate designee most knowledgeable about the policies and procedures regarding verifications of foreclosure documents filed with the courts in Pennsylvania during 2012 and the years relevant to the foreclosure litigation of the Palombos. How's that?
One other issue, Your Honor, regarding the excuse me, regarding the depositions of the three or four existing employees of JP Morgan who were working at or about the time that the verification was issued in Delaware County.
Who are those? Are they part of the employees that are listed in the motions to quash today?
Yes.
And who are they?
Well, as I've mentioned, I have the names of three of them, but there's a fourth.
Mr. Corrado, is that part of your motion to quash? Who are these three people?
Yes, Your Honor. The motion to quash was directed to each notice of deposition.
But
issue.
are any of those people, were they employees of JP Morgan in 2012 and had responsibility for being involved in the verification process in these foreclosure actions in Pennsylvania.
Your Honor, they had no involvement in the Palumbo's foreclosure.
It does not matter whether it's the Palumbos. I was very specific about my question. Did they have involvement?
I don't know, I can't say sitting here today whether they were
Okay.
employees
So I'm
in
gonna
2012.
say JP Morgan shall also produce of the any of the employees listed in today's motion that had involvement in verifying pleadings in Pennsylvania during 2012. Okay, so it's up to you. I don't know if they did or didn't, but if they had responsibilities for verifying pleadings in Pennsylvania during 2012, then you do need to produce them.
That's verifying foreclosure pleadings, Your Honor.
I said verifying pleadings in Pennsylvania during 2012. Pleadings, I can say related to foreclosure actions.
Your Honor, that would take additional discovery because we can't say for sure that any of those people.
Well, then you can actually file a motion for extraordinary relief. I'm just trying to get some kind of way to get through what's presented to me today. That's
Yes,
the
sir.
order today. And
We've
you guys-
recently filed a motion for extraordinary relief, which you denied.
Well, then it's denied.
Your Honor, for the corporate representative deposition, we would ask for a time frame of 60 to 90 days to produce the witness. That wouldn't affect the case track of this matter or any of the scheduling. Discovery has already closed. Your Honor denied plaintiff's motion for extraordinary relief.
The party may work cooperatively to complete the discovery subject to this order within the next 90 days. If you need to file any kind of follow-up motions to this order, you can file a motion for extraordinary relief to ask me to put it on the discovery list. But that doesn't mean you get to do discovery on anything else. And you guys work cooperatively to get this order complied with. All right?
Thank you, Your Honor.
Thank
Very well,
you.
Your Honor.
Thank you,
Tina,
counsel. You'll get a notification of your order. All
We-
parties
we
are
may-
excused.
We may need need you to dictate the order, Tina, for today to make sure it's accurate. I'll have Ellen let me know, because I have some notes, but I don't know if they.
I think I'm okay, but I can go over
Okay.
it at the end.
All right, thank you.
Thank you, counsel.
Thank you.
Next case, Your Honor, is case number 3. O'Donnell, case number 3. Going to ask to move it, to identify yourself for the record and who you represent.
Good morning, Your Honor. Aaliyah Robertson on behalf of plaintiffs, the O'Donnells of Klein Inspector.
Respondent.
Good morning, Your Honor. My name is Gabor Ravari, and I'm here on behalf of the defendants, the Pennsylvania Hospital of the University of Pennsylvania Health System.
All right, what number is this again, Pete?
This is case number 3, Your Honor.
All right, let me look and see. Now, why can't you guys work this out?
Your Honor, for the most part, we have worked it out. And when I say for the most part, I guess I mean half of it is worked out. Counsel did provide me with a date for the deposition of the defendant whom I requested, Dr. Nazarian. I'll be deposing him on November 18th. So that portion of the motion is worked out. The second portion of the motion dealing with defendant's discovery responses. I did receive responses, Your Honor, on October 6th. The problem that I'm having now is, I would say about 85% of them were objections. I think defendant's position is that I need to file a separate motion because I'm not happy with the responses that I got, but because the deposition for Dr. Nazarian is scheduled for November 18th.
Yeah, but what I don't understand is why can't you work that out? What are you looking for that you didn't get? And what are the objections?
Sure.
What is it you're looking for?
Sure. Defense objected to the totality of my credentialing interrogatories. They did not provide any substantive responses whatsoever to those. I'm seeking a privilege log for any objections that deal with any types of privilege.
You guys are going to be involved in full-on, head-on peer review discovery that you're not going to get before the deposition. That's just the way it is, because it requires a full, if you're fighting over credentialing, and this is just a practical reality, you can decide from there what to do, but you're not going to just get the full credential file. You guys know that. You're a good firm. You know that. So why not try to work through it about what is it that you need before the deposition and what isn't, because it's not just a privilege log. That's a whole separate hearing. And I am going to just give you a special master and you guys can go, because the law on this now is very clear that there has to actually, can't just be a privilege log. They actually have to set forth very clearly all the details of the different things. And it can create, I've had these cases, I started with the 2019 program, and I think we had cases that we started litigating in 2021, and they're still not done on the credentialing issue. And I'm not going to just stay your discovery. So you're not going to get that. It's okay. The credentialing file, you guys are going to be in litigation on your own. And yes, you do have to file a separate motion on that. You can't just, because you're going to, the reason is you guys are going to be fighting about this for the next year.
Well, at a bare minimum, Your Honor, are you including the personnel file of the doctor within that?
I don't know, but I can't. This is what you guys have to understand. I cannot take big issue like credentialing, which everybody knows is a real discovery dispute, and then lump it in with the other objections. So let's take the credentialing stuff and put that off to the side. What are the other objections that are part of the discovery dispute?
Well, that was actually my clarifying question, because at a bare minimum, I'm just looking for his file prior to his deposition. So if there's anything related to the doctor.
Well, that's not what your order asks for. And you guys have to understand that I'm not a hot court. I think you guys know that. If I was a hot court, I'd do nothing but do discovery, because I would be reading all of your papers for 50 motions only to hear 2 at the time of the discovery. It's impossible. You know, I mean, I think that you guys should all have to sit around and see how much discovery you have to do now, because everything's by Zoom, because everybody can call from their offices. And we work really hard, but I cannot possibly, no, this was just, okay, a deposition and get me the discovery you owe me. I hear you got some of the discovery, and now you have a legitimate credentialing file. You guys should be able to work out whether you get the personnel file or not. That shouldn't have to come from me. And if it's coming from me, this case has been around since 2019. Why are you just getting to this now?
His deposition is next month, Your Honor. That's why.
So what? Why are you just fighting about this now?
I just got the responses 3 weeks ago.
It does not matter. Come on. Why it sounds this case sat around for a little while, because isn't Dr. Nazarian one of the defendants?
He is, Your Honor. Yes.
All right. So I'm going to put this on the feet of both of you. The case was filed in 2019. You could have filed a motion to compel at any time, that because you didn't get the responses. I get it, right? I get it. You're being nice, trying to work it out, but you can't come at the end of discovery with a credentialing problem in front of the court. You guys have to get back, and you got to get your discovery stuff to the court sooner, so that I can get you an answer before the end of your discovery deadline. Because when's your discovery deadline in this?
December 5th.
Right. Well, you're not going to get an answer by December 5th, but you guys are going to continue to work cooperatively to get what you need. I'm not telling you don't get it, but you guys are behind the 8 ball in this case. You guys should be getting your expert reports and trying to get this case settled. Right? I mean, I'm sure that you know that you're getting ready for your expert reports. I'm sure the plaintiff had their expert reports and kind of knew who you were going to use at the beginning of the case. So, I mean, but you guys need to, particularly because the chances of you getting a trial date before 2024 with your deadlines the way they are now are small. You don't want an extension of that deadline or you'll never get a trial date. So you've got to work this out amongst yourselves. So Mr. Ovari, you need to give to Ms. Robertson the materials that you know darn well are not credentialing. Okay, come on. You guys have done this for how long? You know darn well what's not. You just do. And the stuff that really is credentialing, you need to get, you know, say, listen, here's where we're disputing it, personnel files. I've ruled on this issue and other matters, I think, involving your firms or firms that you should have orders, and just follow those orders. Okay. But what I'll say is that I'm going to, so that you don't have to have an extension of your deadlines. We're going to say motion to compel responses and to compel the deposition. It is ordered that the plaintiff's motion is I'm not, that it is ordered and decreed that, and we're gonna cross out plaintiff's motion is granted. It's gonna come right out of there. It's almost like I'm gonna give you a discovery order, all right? That the parties shall work cooperatively to delineate the parameters of the credentialing dispute, comma, and provide, okay, make period. Defendant is to produce all non-peer review personnel records and related materials, okay? So you're gonna have to go through and look. You guys are gonna have to, this is something you guys are gonna have to work together. The parties agree that Dr. Nazarian will be produced for deposition within, what did you guys say, 30 days of today?
Yeah, I mean, we have a date. It's November 18th.
That's fine. You're agreeing that's within 30 days. Cross out the failure to comply. All right. And what that order will do is give you the ability that if you need further orders to work out the credentialing dispute, you can file a motion for extraordinary relief. It's to have the credentialing issue presented to an appropriate person. It might be Judge Schulman by that point in time, because this isn't really it's a discovery dispute, but these credentialing disputes, if they're real, they need a hearing. They need the defense to put forward all the different stuff and maybe you can get what you need without it. All right. And maybe, some of these questions are going to come up with the defendant at his deposition. So he's got, it might be that you take a little break from the deposition and have the you have the materials kind of there, because you kind of know, you might be able to establish what is and isn't actually subject to any peer review right in his deposition. Okay, so see what you can do about working it out. I will give you the order so that if you have to follow up on it, you can follow up on that order. Okay,
Judge, appreciate it.
You guys got to get these peer reviewed things right at the beginning of your cases, because I'm just giving you fair warning about 2022, which I'm going to take over in a short time. I will not be granting any motions for extraordinary relief. So get ready. All right. I granted them all during the pandemic. All of them. You guys asked for it. You got it. Right. Because what were we going to do? It's a whole new different world. You will not be getting motions for extraordinary relief unless you really like this one. Your discovery was out there in April. I would have been like, too bad. You guys are very experienced lawyers. You can work this out yourself. Not to say it's not a real dispute, but I'm not working it out for you. Motion for extraordinary relief is denied. But what I am doing, and we can even write on it, the parties may file a motion for extraordinary relief to present the credentialing issue to the court. Okay, so that's not going to get subject to the, guess what? We're back. And we're, some of your 2022 cases are going to go to trial before your 2019 cases. I'm sorry for that, but that's what's going to happen. Okay.
Understood, Your Honor. Thank you.
Just a quick question, Your Honor. I know plaintiff's proposed order indicated the 10 days. Is that part?
No, that's out. I took
Okay.
all that. Essentially, I'm just using the order. I'm not even saying it's the motions granted. I'm just putting it down as here's what you guys are going to do to finish off what you need to do. Essentially, you're going to work cooperatively to get the deposition done, to produce over those things that are not really credentialing information, and then work together to get this credentialing issue in front of the court in the way it needs to, which might be you have to ask questions at the deposition itself. Okay?
Understood. Thank you, Your Honor.
Thank you.
Thank you, counsel. You're going to get e-notification of your order.
Thank you. Have a good one.
Next case, Your Honor, is case number 6. Case number 6, going to ask the movement to identify themselves for the record and who they represent.
Roland Christensen and Patrick Fitzgerald, we are here on behalf of the plaintiff, Your Honor.
And Thomas Riley is here on behalf of the defendants, Your Honor.
Okay, so what are we fighting about here?
Real briefly, Your Honor, we had a couple status conferences with you. We have our mediation set up in December with Judge Rizzo. And one of the things that we were trying to work out is we would like the rest of the insurance tower. And in the briefing, we've kind of, and in conferring in our breakout room, I'll tell you what the plaintiff's position is to try and just make it very narrow for you. Based on reading the defendant's response, a lot of the pushback is these are not typical insurance policies. They have trade secrets, whatever in them. They're big, long policies. What we told Mr. Riley is we just need to know the deck pages. Like we just need who the insurance carrier is, right? What the layers are.
Why can't we get the information over without having to produce all the other stuff, Mr. Riley?
Your Honor, that was just brought up. I will bring that to my client, but the point is, they've been given $11 million of insurance policy information that's essentially a primary set of policies.
How about if what I do is I say that it has to be made available for the mediator on, when's the date of your mediation?
December 6th.
Why don't I just do something like that and say, the motion is hereby ordered, cross out everything else and just say the defense must have the requested insurance information available for the mediator on December 6th. And then you can give it to Judge Rizzo. She has it. She knows what to do with it. And then you guys can talk through her about what's to be kept confidential and what's not. Would that be acceptable?
That's fine for the plaintiffs. We just want to make sure Judge Rizzo knows where the breaks are so we can negotiate.
So that's what I'm going to do, Mr. Riley.
That's fine, Your Honor. Your Honor, that's fine.
Therefore, you're not producing it. It has to be available for her. And then at some later date, if that's not enough, we can fight about it later. Okay.
Yep. Totally works.
Thank you.
Thank you.
Thanks, Your Honor.
Is that do we have anything else, Pete? Is that it?
Your Honor, that concludes your list. Pete had to go over to Commerce